Thank you. My name is Ken Vercammen. I am an attorney in Edison, New Jersey, not that far away. And oftentimes we have programs on like wills, powers of attorney, but the library say, hey, there's lots of those. Let's do something different. Duties of the executor and how to make things as easy as possible for them. So, I often talk about, people sometimes even say, well, why do I even need to have a will? If I'm married, doesn't everything automatically go to my spouse? He goes, well, not if there's children from a prior relationship, but that's not really doing planning. That's just trying to punt everything to everyone else. So when there's no will or the will is declared invalid because it was improperly prepared, improperly signed, the procedure to distribute assets becomes much, much more complicated. So that would mean that if there's no will, all the children have to agree upon who would be the administrator. They would all have to sign a renunciation selecting someone to be the administrator. Then they would have to sign in front of a notary, file it with a fee in front of the surrogate, and that's where everyone agrees. If someone doesn't agree, then the person who wants to become the administrator has to have a complaint order show cause filed in a superior court in order to become the administrator. So whenever you have to, file procedures in superior court, I tell everyone, plan on spending $3-4 grand. By having the will, it costs less. If there's no will or the will is declared invalid, the person who wants to become the administrator has to then pay a fee and obtain what's called a surety bond. So the whole idea is to try to make things as simple as possible. So let's say someone passes away. Well, believe it or not, New Jersey is the probate easiest state and the least expensive when people do things ahead of time. Who could believe that? So logistically, what we need to and the surrogate's office was closed for almost 2 years. So, but what we started doing is we have an interview form where we ask all the questions that are on either the probate sheet or the New Jersey inheritance tax form. And again, it is not that complicated. So, what you want to type up for the attorney is the executor's name, the name of the person who passed, the date of death, and much of this is on the death certificate itself. Their date of birth, the location of the original will. Only the original will can be admitted to probate by a county surrogate. Think of a surrogate as a fancy name for the will clerk. If you have the original will, death certificate, check for $160. The attorney fills out the form for you, sends it in. Eventually you'll get your papers. Pretty easy. Now, also, so what's the other information that is provided to the surrogate? Let's say, the address of where the person resided, because probate has to be in the county of domicile of the person. So they look at the death certificate. Just because someone was visiting someone in Monmouth County doesn't mean it goes to probate wherever. Sometimes we have to, kind of fight because there's a situation where, someone could have been living in Monmouth, but they passed away in Hunterdon, and they were at a nursing home for a week or so, and they put down county resident in Hunterdon. No, we want the stuff done in Monmouth. There's a question: what real estate is there in this state of New Jersey, and what real estate is there in any other state or country? New Jersey has jurisdiction over New Jersey real estate. If there's real estate in another state, then there has to be a thing called ancillary probate. Let's see. And then we ask questions basically on what assets people have. And it's a good idea to start typing up, because eventually you have to do it. The assets, their account numbers, and the approximate amount, not to the penny. Now, and then, ballpark what expenses there are, what expenses are in the future, and a couple things, who inherits under the will, and their address, and then the listing of if there's other children who was disowned, nothing to that person. All right. So the paperwork gets sent to the surrogate's office. What we've been doing is faxing or emailing a copy of the will, copy of the death certificate, copy of the information sheet. Then the surrogates in different counties will send to the attorney the papers to be signed in front of the attorney or notary. Then we have to either have hand delivered or by certified mail, Federal Express, the originals of the will, death certificate, and the money. And then in like 10 days or so, the surrogate will send what's called the letters testamentary out. And the letters testamentary, I tell those are the magic papers that the person who is the executor can do stuff. Just because someone's named in a will, they have no legal power to do anything until they get the letters testamentary. So what next? The executor is required to have sent to all the beneficiaries what's called the notice of probate. The notice of probate says the will was admitted by the ex-county surrogate on this day. The name of the executors is, that's their address, and a copy of the will be provided upon written request. In many of the probate matters, I suggest the executor, listen, why don't we should just send them a copy, or it's better if you even email them a copy, because transparency is best. The cases that oftentimes go to court is where the executor doesn't provide information to people, and then they want to file a complaint saying I have not been given anything, and I want them removed. Remove them. Now, in addition to having a notice sent to the beneficiaries under the will, there has to be a notice of probate sent to anyone that would have inherited if there was no will at all. When there's no will, that's called an intestate estate. We'll talk more about that later on. Okay, then what the executor typically does is say, okay, figure out, okay, let's look at what all the assets are. What do we need to do? The executor needs to set up an estate account. The executor needs to obtain a tax ID from the IRS. You can get it in 15 minutes by going to their website. If you request it in writing, it takes 4 weeks. Doesn't make sense, but that's the way it is. Then the executor needs to see, are these assets, do they have any beneficiaries on the assets themselves? Let's see, the will only controls assets that do not have a direct beneficiary. Certain assets go directly to someone who is named on it. It's either by title. So the most common example is when a house is owned husband and wife, automatically goes to the survivor. The will cannot change that. Let's say then. There is, and also bank accounts. If it's payable upon death, POD, joint tenancy, automatically goes to the survivor. Some assets pass by contract. An IRA, 401k, life insurance, annuity, anything that has a direct beneficiary. A will cannot change that. So in one of our recent, estates, the will said, okay, this account goes to these couple people, but by the time the person passed away, he changed who the beneficiary was. So the beneficiary went directly to his new wife. Well, the will says one thing, the account says the other thing. What wins? Whatever was listed as the beneficiary on the account. The will cannot override that. So it's important. I recommend to people when they're doing their estate planning, it's a good idea to get your document, to get a printout. Don't rely ever upon what someone tells you over the phone. And it also helps out the executor. Part of doing planning is putting stuff together. Some people, when they do their will, they also prepare what's called a letter of instruction saying, listen, to try to make it help you out, this is who my attorney is, this is who my accountant is, this is my financial advisor, this is where I have my stuff, and there's no hidden money in the walls or under the bed. There's nothing there. Next, now, believe it or not, New Jersey reduced some taxes or did away with some taxes. 2 years ago, New Jersey did away with the New Jersey estate tax. There is still a federal estate tax, but that only applies to the people that live in Rumson that have more than $12.6 million, or the people that live in Deal on the beach. Everyone else, there's no estate tax. New Jersey reduced the inheritance tax. So there's no inheritance tax if it's going to spouse, children, grandchildren, stepchildren, parents. But inheritance tax forms do need to be filed and waivers obtained when there is a house. If monies are going to brothers or sisters, the first $25,000 tax-free. Then after that, it's taxed at 11%. If it's going to bona fide charities, churches, library, foundation, then there's no tax. But if a charity is receiving any money, then in addition to the charities being advised of the bequest, there has to be served upon the Attorney General's office this notice of probate, and the monies can't be distributed to anyone until the Attorney General goes and says, say that they approve it, and they don't get back to people sometimes for a year or more. So it's a project. So let's say what happens next is we file the inheritance tax return. We have to provide them also with a copy of the a income tax, whatever the last person's income tax return is. Sometimes the family can't find the most recent one. We says, listen, that's fine. Just try to find one recently, because especially if there's no tax that is due, then they're going to say, just give us anything. When there is a tax due, they've been 13 months behind in Trenton. So I've been telling clients, listen, we should try to file the inheritance tax return right away, not to wait. File right away, even if it's missing things, to be determined, unknown, etc. We can always update it, but at least we get online. If you get to Disney World early, you get online. That's good. If you step off the line, let's say you have your friend hold your spot when you go to the ladies' room, but when you file with the Trenton Inheritance, you're filing, and then you can supplement it. All right. Next, we look to see what real estate there is, and then basically the executor makes the arrangements to have the house cleaned up and then listed for sale. An executor is entitled to a commission. The executor gets a commission of 5% of the first $200,000 and 3.5% of the next amount. Many executors don't take the commission because, number one, it's taxed to them as income, but number two, there is kind of an overreaching if there's two brothers and sisters, three brothers and sisters, and you're taking extra money by not really having to work hard, then everyone else will be angry. Sometimes we have it as a hammer at the end to encourage people to sign the release and refunding bond to make sure that to say, listen, we won't take the commission if everyone cooperates with us and doesn't give us a hard time. The executor also has to make arrangements to open up an estate account with a bank using the tax ID. The executor also then looks to see, okay, what assets do we have? Liquidate the assets. New Jersey did away with what's called the notice limiting creditors notice. A creditor has 9 months in which to make a claim. And if the claim is disputed, they have 3 months in which to bring a lawsuit. Interestingly, that does not apply to who? Doesn't apply to government. Doesn't apply to Medicaid. Doesn't apply to other governmental debts. So it is important that the executor does not give out money to anyone, because sometimes Medicaid doesn't let people know for 9 months a year that money is owed. All right. Then what? Then and it's also a good idea. I've been telling executors to keep people apprised every couple weeks, saying, okay, this is what's up, this is what's up, this is what's up. People complain less when they know ahead of time what's going on. And on the Monmouth County Surrogates website, they have interesting information for executors, on what their obligations are, what their rights are. So, you can look at the Monmouth County website. Now, let's see. What if I mentioned earlier, if there is no will, then they all got to agree upon who's going to be administrator, and then the administrator has to take out a bond. If everyone doesn't sign a renunciation, then it go in Monmouth County, goes to good Judge Quinn, who will have to appoint someone to be the administrator. It's not required under the law to get an attorney, but it's usually recommended because the attorney will make it easy for you, and especially when there's a couple beneficiaries, you're not paying anything. There's no law that says you got to change the oil in your car all the time, but you're better off having a professional do it. Some people try to do their own electrical work and their own plumbing work. If they're able to do it right, well, they're doing it at a risk. If they didn't do it wrong, then the house burns up. I wanted to try to get out the surrogate's office actually has different booklets, and they just reopened to the public. Now, the estate account, I recommend that the executor try to use the estate account to pay all the bills, because at the end of the case, then they can use that as their informal accounting and provide that information to the different beneficiaries. Interestingly, in New Jersey, if someone is married but they have children from a prior relationship and they pass, the spouse does not get 100%. Those children get something, and if the person was married but have no children, then that person's parents get things. So a lot of times you got to think, okay, it's better advice is get a will done so that there's no mess. If there is, sometimes there's children under the age of 21. Well, I'd say if the will does not provide otherwise, they get their money on the day they turn 18. Well, I'd say how many 18-year-olds do smart things with money? Not that many. So it's a good idea for people to put in their wills that the grandkids or kids get the at an older age, but it can be used ahead of time for health maintenance support, college, etc. Let's see. Now, for the inheritance tax return, let's say to not be taxed, it has to be a bona fide charity, one of those 501c3 charities. I'd say it can't be. You can't give it to the person down the street. That, well, you can, but there'd be a tax. There'd be a tax that is doing that. When you're selling the house, let's see, some people want to sell it themselves. Some people get the realtors. The whole thing I tell the executors is, how much work do you want to do? Let's say because a lot of times the realtors earn their keep, and the issue sometimes is if there's no realtor, the people keep asking me what to do, and he goes, hey, listen, these are things that your realtor would have did. Now you pay me, you have to pay my office money on what to do. You want to make sure the house is sold as is. Don't sign any contract or addendum that puts obligations upon the executor to fix anything up. The typical buyer is entitled to, usually under the contract, be able to have a home inspection report, radon report, termite report, etc. If there's a problem, then the clauses often say either site can canceled. Sometimes there's a give back of a couple grand to just move it along. Then the buyer will obtain what's called the title search to make sure that there's no old liens against the property that the executor may not know about. The executor is required to sign to the title company or sign what's called an estate questionnaire. The attorney will prepare the deed, the affidavit of titles, the seller's residency form, a 1099, and some other things. We try to send all these weeks ahead of time before any kind of closing, and if possible, we try to have it signed ahead of time. During COVID, we were doing everything by the mail. It's reopened. Some executors want to go to the closing this way; they can be sure of getting their checks that day. A couple definitions in probate. What a codicil is, it's an amendment to a will, let's say. We've been doing new wills because of computers and everything. If a spouse is disowned, they can file a caveat against the will and then file a complaint or to show cause to get 1/3 of what's called the augmented estate. Some wills provide for a testamentary trust, I mentioned, for children. Sometimes it's a testamentary trust for a spouse. It could be a second marriage situation. Sometimes there's a testamentary trust where one of the children might be someone that should not be getting money. They could have alcohol problems. They could have drug abuse problems. They could have financial problems. They could have any kind of problems. The good thing with the testamentary trust is it's protected from taxes, government, Medicaid, everything. We handled helped out in a state where there was a testamentary trust set up for this guy that was in his 50s because he was an alcoholic. And his ex-wife filed a complaint saying, I'm owed alimony. I want you to compel the trust to pay me money. And the judge agreed with us. The reason why mom set up a testamentary trust is to protect the assets, and that way it can be used for his rent. It can be used for his car insurance. It can be payable for food, but it just could not be just blown. So it's kind of important where someone has children that shouldn't be inheriting, to do the work ahead of time. And I tell people try to protect them as much as possible, because as I said to the judge in Somerset, people have alcoholism is a medical issue. If you give an alcoholic $100, they'll probably spend $100 on booze. If you give them $1,000, they'll buy $100 worth of booze, blow the rest, and then the person has no money, for the rest of the month. Once the executor has basically paid the bills, and the executor has received, things along the way, we have to wait for what's called the tax waiver on the real estate. Then we file that with the county clerk's office. That way, that it proves that there's no inheritance tax due on the real estate. With some of the bank accounts, when there's tax due, we have to wait for waivers from Trenton on those accounts. But in the end, unlike in other states, probate is very, very, very complicated, and every step along the way needs to be approved and fees paid. My mother-in-law used to call me every other year, I want to come in and get a trust done. I want to get a trust. And I would say, were you watching Susie Orman on TV? And she would say, oh, yes. So I tell my mother, listen, Susie Orman is exactly right. If you live in New York, California, Florida, where probate is very, very complicated, but New Jersey is the probate easiest state. So I tell people, I ask people, why do you want to spend $3-4 grand on a trust, $5 grand, when a $400-500 will suffice for most people? All right. So now that the executor, or when there's no will, the administrator, they've liquidated the assets, the money's in the account. What the executor typically does is prepare what's called an informal accounting. So what we like to do is do an Excel spreadsheet, and I tell the executor, listen, email that to all the beneficiaries, email that to all the players, together with the bank statements, so they can see everything. We want to be as open as possible. Then the attorney prepares what's called a release and refunding bond for each beneficiary. It's a piece of paper. It's not, but what, think of the release and refunding bond is where the beneficiary said, okay, I'm getting X amount of money. I've reviewed the informal accounting. Listen, I'm satisfied. I want to get my money. And each of the beneficiaries has to sign the release and refunding bond in front of a notary. And then what's called the executor has to take the release and refunding bond. If it's an administration, it must be filed with the surrogate's office. It's not where there's a will and it's probate. It's it's not 100% required to be filed, but a lot of my executors say, I want to file with there because I don't want to be having to keep it. I'd rather have it on file there, so I don't have to keep stuff for years down the road. If everyone signs in front of the notary, then the executor can cut a check and they're over it. The thing with the release and refunding bond is, let's say all the money is given out, and then there was an unknown debt that's a bona fide debt and not barred, then the people have to, quote, refund money. And let me tell you why that's important. Two ladies were in our office. They were co-executors, and they decided to cheap out, do everything themselves, not get a lawyer. And, they distributed, the money to everyone under the will, and, after they distribute everything, they get a notice from, the state saying there's a Medicaid lien of over $100,000. So they come to see me, and I goes, well, Medicaid is a priority. Medicaid has to be paid out of the estate funds. Let's see, that's why you had the people sign release and refunding bonds. And they said, oh, we didn't do that. No one told us to do that. He goes, well, it's not that no one told you to do that. You were acting on your own. It's like going to a foreign country, committing a crime and saying, oh, but nobody told me that this was a crime here. Well, you're going to be saying that from, a jail cell. The bottom line is that, at least the attorney will keep you on the straight and help you out. Don't try to do your own electrical work. And there's some people want to read and learn how to do it themselves. I do enough reading on things. I don't want to learn anything new. And when I had my knee surgery, I didn't ask the doctor a lot of questions on how you do knee surgery. I said, doctor, you've done this before, right? He goes, Kenny, I could do this almost in my sleep. I've done 1,000. He said, okay, good. Let's say one of the beneficiaries does not sign the release and refunding bond, or they can't be they can be located. We sent it to them. What has to happen then is we send another letter to everyone. And that letter says, under the law, everyone has to sign a release and refunding bond. We have received release and funding bonds signed from everyone except for Uncle Joe. And unless Uncle Joe signs the release and refunding bond, that means we're going to have to file a complaint order show cause in Superior Court, asking a judge to review the accounting, having the surrogate do an audit on that, and it's going to cost thousands of dollars, and it's going to delay everyone getting their money by half a year. However, if Uncle Joe signs it, then in front of the notary, then that can be avoided. By the way, this is Uncle Joe's phone number, their address, their email, where they're at. Hopefully, the family can lean upon them. But in other states, probate is the devil. Florida, every step along the way costs fees. So, in Florida, other states, we recommend that people have have their properties owned by a trust. It varies from state to state. New Jersey is the easiest state. All right. So, in a nutshell, that is probate in New Jersey. Sometimes, though, you get an executor that doesn't do what they're supposed to do. Let's see. So we're going to spend the last 5 minutes talking about other issues, because I I always go over again. My topics are duty, probate of the will, and duties of the executor. Well, the executor is the fiduciary. Their duty is to follow the law and do the right thing. Sometimes, people want to contest the will because it was changed right before someone died. But just because someone was disowned does not, automatically give them the winner. So I was handling a contested probate. The will was admitted to probate, and these people filed a complaint saying the will should be thrown out because basically they didn't, get what they thought was entitled to them. But our response, to the judge was, okay, judge, this will was done 10 years ago. Let's say, and in those 10 years, the grandchildren challenging this didn't visit grandma in her house. Let's say, for 5 years, they didn't send grandma a birthday card, a Christmas card, a cake, had no contact at all with grandma. Why should they be rewarded now because they weren't helpful? Now, I've had people say, I want to challenge the will. Okay, I wasn't left, my brothers, used undue influence and screwed us. Well, when's the last time you met with your dad? And he goes, not for years. So he goes, well, you don't really have too many grounds to contest it. But there is more and more what's called undue influence. It's where, let's say, the older person was under the influence of someone. They depended upon someone to do everything for them, and then magically a new will is signed where everyone else is kind of screwed. There's a complaint order show cause filed in the Superior Court. The judge sometimes permits what's called discovery, interrogatories, depositions, and then there's sometimes a hearing. In Middlesex County, all the cases are sent to the free mediation. In Monmouth, often, the judge will say, hey, you attorneys agree upon a mediator and try to mediate it. And that's usually successful because most people want to resolve their issues. Other times, it's not that the will is being challenged. It's that the executor is not doing what they're supposed to do. A year's went by and we haven't heard from the executor. Then the executor doesn't respond to calls or emails, etc. And the family's starting to get a little worried that, hey, how do we know they didn't go south with the money? How do we know that they just didn't take the money and buy the most expensive Mercedes from Ray Katina? Before filing a complaint, in those cases, we feel it's appropriate to send a few. Well, usually first I tell my clients to send a couple nice letters, and then we send a couple non-threatening letters. Then if there's no response, and also there's no attorney, okay, let's file the complaint. Then let's bring it in front of the judge. Let's see, handling a case now. Let's see, mom died a decade ago. The brother who's the executor is still living in the house. Let's see, well, everyone else wants their money. He doesn't respond to anyone. He blocks their calls, etc. It was the judge. Okay, we tried. We sent him a bunch of letters. Let's move on with it. When we get one of these people that's been living in the house for a lot of years and misusing the assets to pay all the house bills, then we'll also say, Judge, by the way, we ask that you remove the person as the executor, compel an accounting, and ask that you charge them rent for the time they were there. Becomes a judge call. Sometimes the executor is misusing the money to support their lifestyle. Okay, Judge, let's remove that person, and also have in the order that there not be an executor's commission. They shouldn't be rewarded for doing the wrong thing. But again, probate is not that complicated in the state of New Jersey. And now I'm going to put in the chat a website that we have put information that is helpful. Our website is njlaws.com, and I'm going to put it in the chat button. So I put in the chat also, some of the people who work for companies have prepaid legal plans, and it covers wills, power of attorney, living wills, and if someone is an executor, them being the paying the legal fee. So that's almost a no-brainer. As a courtesy for someone who's people who are nice enough to attend and watch some of our programs, typically my office charges a $200 consult. But if someone contacts us, let's say they want to do a will or want someone, then we don't charge them the consult fee. If they fill out our questionnaire, and I put that in the chat also. But the whole thing is, don't be a putter offer. Don't be a putter offer. Don't be a putter offer. Let's see. We've never had anyone after doing a will say, "Oh, I wish I didn't do that." So, and having a will done is not that complicated. Same thing. We have a questionnaire we email out to people, and it says, okay, who's executor one, who's executor two? You don't want to have joint executors. And then doing the will, the attorney's going to ask you, okay, tell us what real estate you have, and a ballpark approximate of everything else. Since New Jersey did away with the estate tax, I don't need to know about people's details. I just ask them, do you have more or less than $11 million in your accounts? And then in the will questionnaire, you're going to put down who are your beneficiaries. But you also want to have a what if any of those beneficiaries pass away, then who would get their share? Sometimes wills have what's called specific bequests. So a specific bequest says, certain assets or amount of money go to a particular person or charity. So sometimes someone will say, ladies will say, I want my jewelry to go to my granddaughter, because they know that if their son will just give it to cash for gold, and say, what do you give me for this junk? Some of my clients that are retired law enforcement, or they are sportsmen, they have firearms, they leave it to someone that has a firearms permit. And, some people put in their will, I call it the reverse specific bequest. I leave no bequest to X person. We don't leave them a dollar. We don't put a reason. And we just don't leave it. It's, people have a right to do with their money what they want. And for the executor, our rule of thumb is, can they drive to a bank? Can they walk up steps? Can they write checks? We're not anti-senior citizen. We're just practical. So sometimes someone will pass away. They're the executor, but they no longer can drive or do stuff. They don't have email. And if the second executor can do it, I say, listen, it's your option. You can renounce as being the executor and let the other person step in, because that might speed things along. Only the original will can be admitted to probate. A photocopy cannot be admitted to probate. A photocopy, I try to make it easy. Tell people the surrogate's like a fancy name for the will clerk. But if you have a copy, then there has to be a complaint order show cause in front of the Superior Court judge. And there's a presumption, if you don't have the original, that the original was destroyed. So again, that costs the family money. If someone can't find their original will, I tell people, listen, if you can't find it in 40 hours, get a new one done. And also, now, a will that's done in New Jersey is valid in any other state, but make sure that you have a self-proving will. Under the old law, person signed, then there's two witnesses. But then one of the witnesses had to sign paperwork with the surrogate saying they were the witness. Under the self-proving will statute, person signs, two witnesses, then the attorney and notary. Everyone signs again with some language. Then the executor does not have to locate the witnesses and have them sign papers for the surrogate. But if it's done the old way, or a lot of times these people use these cheap things online thinking they're saving money, well, then it could cost them substantially more in having to locate witnesses or file a complaint order show cause. So only the original will can be admitted to probate. Make sure that the original will is self-proving. Make sure that the original will has a clause that says no bond is required. And in my last 90 seconds, because I was only going to go for 40 minutes, but I would be remiss if I didn't talk about power of attorney. A will takes care of your assets if you pass away. Let's say what a power of attorney is. You're giving the power to someone while you're alive to be able to, if you became incapacitated temporarily, permanently, to make sure your bills are paid and do things legally for you. Just because someone's married does not give a spouse the legal right to do everything. So in a way, for married people, the power of attorney is almost more important because, the assets will go to the spouse. But it's also very important for someone who's not married, because then no one can step in and there would have to be a very expensive, complicated guardianship proceeding. Every week we get a call from someone, I need to get power of attorney over mom, dad, or Uncle Joe. Well, you can't get power of attorney over anyone. They have to affirmatively give it to you. And, someone called me, I got to get, last week, I got to get power over someone. No, you can't do that. They have to end the person that they want to get the power of attorney over was in the hospital, they were incubated. Well, someone has to tell me affirmatively, this is what I want. I've went to hospitals, I met with people, I've signed documents in nursing homes and other facilities, as long as they can communicate. But if they can't communicate, I can't jeopardize my license to do something that I'm not 100% sure. So, Jill from the Manawan Library, are there any questions that you want to ask me before we finish up tonight?